geez, what's the real risk here? You're telling me that I'm going to have to hire new people or have to invest in new technology or implement it properly, but what's the actual risk? Well, one of the risks is litigation, right? And it is real. And it's real for organizations of all shapes, sizes, stripes, and colors. We see the CCPA going after certain entities, some of which are a little surprising to us, but some of which are sensible when you dig in. The litigators, plaintiffs bar will go after anyone. We see them going after big organizations, small organizations. And so I'll walk you through some trends and some things to think about and use this as you need in your course of discussion internally and with your counsel. So privacy litigation over the matters we're talking about generally, I think, has continued to remain high from a new filing perspective. We're still seeing the continuation of trends over lawsuits related to Pixel and other technologies on websites. We're starting to see and continuing to see a continuation of the plaintiff's bar complaining about whether or not that information is being collected consistent with old laws and new laws, including the wiretapping laws that in some states have been on the books for literally decades. We're also seeing the plaintiff's bar continue to exploit statutes like the VPPA, the Video Privacy Protection Act, as well as certain state laws like the biometric law in Illinois and the genetic information law in Illinois. So when we go all the way back to the top and we look at the new promulgation of laws, both compliance effort today, but just fast forward a few years, undoubtedly there will be litigation around those, whether they have a private right of action or not. The plaintiffs bar, they're skilled lawyers, they're clever, and they're going to test the limits. And the courts in some states will allow them to. One trend we've seen recently is that the plaintiff's bar is getting better at filing complaints. So it's still a bit of a find and replace for some of these complaints, but they're also expending more effort for certain of their complaints, especially in the wiretapping case, in an attempt to make sure that they can get through the motion to dismiss stage. So the motion to dismiss stage is one where we test application of the law to the facts pled. We don't get to test the facts. And they're using things like CCPA subject rights requests to get information about your privacy program that is in addition to using developer tools and other technology to understand what you're collecting, when consent modules are firing and when you're collecting versus those. So they're getting a lot of information. It's right there, it's available, and they're using data subject requests. If you want to read about one in particular, for example, there's a lawsuit in the Northern District of California against Trade Desk. It's called Mitchie. You can find the complaint, it's publicly available. You can see what the plaintiff's bar is doing with respect to CCPA requests. One of the interesting things we've seen in the last 6 months is that the plaintiff's bar had been pursuing wiretapping cases against kind of consumer brands, so websites using collection technologies like the Meta, the TikToks, and the Googles in healthcare, out of healthcare. They're now turning their attention a bit to what I would say are some of the platform companies that sit right below the Metas and Googles of the world. These are platform companies that help collect, serve ad impressions on a global basis. So kind of the behemoths that help energize the ad tech and martech industries. There are a series of lawsuits now against those companies. There's roughly 5 of them that we're tracking. That's a bit of a shift. It's going to bring the attention of application of these wiretapping statutes and similar collection statutes to the forefront of the discussion within the courthouses.